morning and welcome to another edition of Questions for Lawyers. I'm your host, Jeff Adelman. Today we are, for the first time, live from the new Adelman Injury Law Studios. We got this comfy couch here. We got a new sign. I mean, this is a first-class operation, as you can tell. And I am thrilled to bring to you today Adam Barron, my friend who does workers' compensation claims in Miami and Coral Springs. His office is a few buildings away from mine. Adam, thanks so much for joining us today.
Thanks for having me, Jeff. I've been waiting to, I'm very honored that you'd have me on the show, and I've been waiting to tell everyone what workers' comp is. So thanks again.
Well, I tell you that the waiting list is, it's knee deep. So your number came up. No, I'm really glad that we were able to do this. And, workers' compensation is in the vein of personal injury, but it is completely different at the same time. Can you kind of explain to the audience what the purpose of workers' compensation is and what it is?
Sure. So, workers' comp is there for people simply that get injured on the job. And that's the extent of workers' comp. Some people think it's got to do with being fired, and sometimes I'll get those extraneous calls, but really it's just being injured on the job. And so that's what it has in common with personal injury. We're talking about an injury. What you do is all about injury. What I do is all about injury. But that's really kind of where the similarities end, because in workers' comp, there's things that I don't have to worry about that you have to worry about, like negligence, okay? Negligence isn't really something that factors into workers' comp. I mean, there's like a few, exceptions to this type of thing, but basically, if you're working on the job and you get injured, you're covered. So if a guy is a klutz and God forbid, he cuts his hand off, he's still covered. If the boss drops something on your head from the floor above, you're covered. You don't have to prove who did what. All you have to establish is that you were injured and you were on the job at the time.
And that's a pretty big distinction. And with regards to the type of damages that somebody who is injured at work can get, can you kind of tell everybody what you seek for your clients?
Yeah. So when somebody gets injured and they come to me, the two things that initially I'm trying to get for them is basically lost wages if they're not able to work, and medical care. And that's really all workers' comp, gives to you is those two things. Eventually, I can get them a settlement. So that's where it's similar to personal injury. Most of your cases will eventually result in some sort of, settlement or some sort of award at the end. In workers' comp, you can get a settlement for your clients, but really it's medical care and lost wages. That's what I'm petitioning the workers' comp insurance companies to give my clients.
And you left something pretty significant in my eyes out from the personal injury aspect, those non-economic damages, pain and suffering. That's not something that workers' compensation takes into account.
It's, it's a shame. And, I have to explain it a lot of times to people because they're just, when they come to me and they've never been through the process, I hear it all the time. What about my pain and suffering? Look, I'm in pain every day. I have to get up and I've got this back pain for the rest of my life. And, Jeff, it's hard to explain to someone that has this type of injury. I'm sorry, you're not going to be compensated for the fact that you're in the pain every day. You're experiencing the pain. But what I can get for them when you go to settle the case is we look at what will the future medical care costs be.
Sure.
So that's what, factors in terms of what makes a settlement. But unfortunately, the whole aspect of pain and suffering is not something that can ever be included in a settlement, nor can a judge of compensation claims give them money for.
One of the things that is particularly different about workers' compensation and personal injury is the choice of your doctor for your care. In workers' compensation, do you choose who your doctor is?
So the short answer is no. The insurance company chooses for you. So what will happen is when you get injured on the job, the way it's supposed to work is your job is supposed to send you initially to a workers' comp clinic. I mean, if you're hurt so bad that, you need to go to a hospital, that's fine too, and you can go to a hospital. But if it's not like a life-threatening type of thing, generally speaking, you're going to be going to a workers' comp clinic. They already know which workers' comp clinic they're going to send you to, and you got to go to that one. Then the clinic will make a referral, hopefully, if you're lucky, to a specialist like an orthopedist or something like that. The insurance company gets to choose who that orthopedist is going to be. You don't get to choose. Now, a long time ago, I mean, back when I started practicing, and that was, some 20, 28, 29 years ago, you could you get to choose, pick three from a list they used to send you. They don't do it that way anymore. The adjuster for the insurance company will tell you who you're going to be seeing. Now, Jeff, there are some little tricks that we can do, though, when it comes to doctor selection. So let's say you've gone to a doctor and you don't like the doctor. You've treated with him for a while, and, like a lot of these workers' comp insurance company doctors, they're like, oh, you're fine. Go back to work. There's nothing wrong with you. If you don't like your doctor, I can ask for a change in doctors. And here's where the trick comes in. They have to give me that change within 5 days. So if I fax a letter to the adjuster saying we want to exercise our one-time change in doctors, and they let more than 5 days go by, guess what? I get to choose the doctor. And so once, you get to choose the doctor, you're not going to be stuck with one of these insurance company doctors that are going to say, oh, you're fine. There's nothing wrong with you.
How often does that happen?
Not
where
too often.
Where they let you?
You hope, you send the fax in on a Friday afternoon, you get the weekend. So right there, there's, you got those 2 days, and you're hoping sometimes it works, but a lot of times, a lot of the adjusters are on the ball, and, they will, oh, here's your new doctor. Here's the appointment. They set it up.
How does it work with regards to lost wages?
Sure.
For a injured worker who can't work? How does the insurance company go about making payments or deciding what to pay?
Okay. So when you can't work and the doctor from workers' comp says you're unable to work, totally unable to work, you're eligible for what's called temporary total disability, which pays you 2/3 of your salary. And the way they figure out what your salary is they look at the 13 weeks prior to the accident. And, because it's not accurate to just look at any 1 week, because sometimes there'll be weeks where maybe you've worked a lot of overtime. Maybe there were some weeks when it was slow. So I guess the fair thing that the legislature established 100 years ago was basically you look at the 13 weeks prior to the accident, establish an average, which is called your average weekly wage, and workers' comp will then pay you only 2/3 of that. Okay. Now there's a narrow exception if you have a catastrophic injury where you lose a limb or use of a limb, or then you get 80%. But most of the time it's.
I didn't know that. So there's actually I wouldn't say an opportunity, but if it's a catastrophic injury, they actually have to pay more than 2/3.
That is correct.
In that situation, but not 100%.
No, you never get 100%. That's the nature of the beast. But they're not taking taxes out of your check either. So that's kind of like the trade-off.
It makes sense. Makes sense.
Not that anyone's taxed at a third, but you're not paying taxes on the workers' comp money.
I'm sure that has something to do with it as well.
Yeah.
So let's say somebody is injured on the job. After getting medical care, what's the first thing they should do?
Well, I mean, look, once you're injured, the first thing you need to do is really report. And I know this probably sounds obvious, but you got to report the injury to your boss. Mm-hmm. I can't tell you the number of people that, maybe they're leery about making waves at their job, and they think they're going to get fired, which, by the way, Jeff, it's illegal to be fired by your boss, from your job, because you're trying to claim workers' comp benefits. So, people need to know that, and they shouldn't be scared. But some people are scared and they don't want to come forward. You need to come forward right away. You have technically 30 days, okay, by law.
30 days to report it to your employer.
Right. And there's exceptions to that rule too. But, you don't want to wait all 30 days because, let's say the dispute happened. And let's say there was a surveillance camera that could have seen it, but because you waited so long, they erased the tape and it's not there anymore. Report it when it happens, and don't be afraid to do that. your job pays for workers' comp insurance. That's what it's there for. So if you get hurt, don't waste any time and report it to your boss like as soon as you can.
Even if you don't end up making a claim, even if you heal, it just makes sense to report it to your work because you don't know how you're going to be in a week or so.
It's very true, very true. And there's a lot of that, Jeff. There's a lot of like delayed type of things where, people think they're going to tough it out. And I understand this. The thought is like, I don't want to be a pain. I'm here to do my job, and I don't want to look like I'm some sort of slacker. And a lot of people are like, I can work through the pain. It's going to go away. But a lot of times it doesn't go away, or it gets worse. So you need to err on the side of caution, and you got to look out for yourself because your job isn't looking out for you. You're the one that's got to look out for you.
Absolutely. Insurance companies generally don't look out for the people making the claims. They're looking to pay as little as possible.
Very true. And both what we do, that's cornerstone.
So who is the person that the injured employee should report it to?
A supervisor. And it's not enough to tell a co-employee. Got to tell a boss. Doesn't have to be the president of the company. Just go to your immediate supervisor and you're good. Okay? And what they're supposed to do is fill out a notice of injury. But, where you start to have problems is when these employers, they don't want to fill out a notice of injury. They're either lazy or they just think you're going to go away or something. And then it's like there's such a delay in benefits because your job never submitted the paperwork to the insurance company. Jeff, a lot of times people will come to me, and the first that the insurance company is hearing that the guy got injured is when I send them something. And, that delays the time that the injured worker could have been getting benefits, but because the employer didn't send in the notice of injury, that's what it's called, because they didn't do what they were supposed to do, it can really delay your benefits.
Isn't there a potential for a whole he said, or he said, she said about if the person actually told them about the injury? Wouldn't it be better to maybe even send an email? Just wanted to let you know I was injured on such and such a day. I'm getting treatment. I'll keep you in the loop of what's going on.
It's an interesting point that you raised because I just recently had a case where somebody claims to my client reported the injury and she didn't really pursue her rights. The statute of limitations ran, okay? And this is just like what we were talking about in the sense that she got worse. And then she finally decides she wants to pursue it. The 2-year statute, the initial statute of limitations ran. But I was able, because she documented, through emails or texts, she reported that injury. And if you report the injury and you do what you're supposed to do, and they don't furnish you with the things that they were supposed to furnish you with, like, letting you know, like, first of all, they were supposed to report it once you tell them. They're supposed to do a notice of injury. And they need to let you know about the statutory, statute of limitations and stuff like that. Because they didn't do what they were supposed to do, it told the statute. And she was still able to go forward with the claim.
Because she had documentation.
Yes, it all stems back to having an email or a text. Very important.
Isn't that amazing? Because there's so many ways for you to document now that there weren't before. Yes, of course, there was fax machines, but the line could be busy. But sending a text, sending an email, I mean, it's evidence every time you do it.
Yep.
Now, tell me this. What if your boss is not cooperating?
Listen, it happens a lot. And the only good answer I can tell you is you got to see me. Because a lot of times, an injured worker will just get nowhere with the boss. Jeff, I had a guy come in yesterday. This is a poor gentleman who was a migrant farm worker, and he's picking oranges. And he was up on a ladder. The ladder starts to fall over. He grabs the branch, and he gets he lacerates his palm, and he gets like a splinter in there. But he thinks that, he tells the boss doesn't do anything. And, he's a trooper. He wants to keep working. He tries to see if it'll get better. The thing got infected. He has to go to the hospital, and then they have to operate on him.
Wow.
Yeah, and it's a mess now. And the job is like, oh, yeah, well, we're going to take care of it. We're going to take care of it. They don't do anything. this guy doesn't have the wherewithal to make this happen on his own. There are times in life, Jeff, as you know, you just need an attorney's help. There's no one else that's going to be able to do it for you, but someone like us, someone like myself that knows what to do. You just have to get an attorney's help at certain points in this.
Well, for those of you out there who don't know this, I think I have to ask this question. How do you get paid?
So there's a couple ways that I get paid in a workers' comp case. If I settle the case, I'll get a percentage of the settlement. Mm-hmm. And, some attorneys charge different things. I charge 25% of the settlement. Some attorneys charge more. There's another way, though, Jeff, that I can get paid even if the case doesn't settle. If I take a case all the way to a judge of compensation claims and I prove to the judge that, they owe my client benefits, the the insurance company is going to have to pay me a fee based on the time that I expended in, prosecuting the claim. So, it can work out one of two ways or sometimes a combination.
One way or the other, though, if somebody comes to see you for representation, are they going to have to write you a check or give you a credit card?
Never. It's like you do. It's contingency on their part. They will never have to pay me anything, never write me a check or anything. I get paid from them only if there's a settlement. Sometimes I get paid by the insurance company. Listen, I got cases where I don't make a dime because, sometimes the client doesn't want to settle and workers' comp is doing everything they're supposed to be doing, and that's fine too.
Let me ask this. What happens if you have a situation where an employee is being paid in cash? They're getting paid, not a check, with, Benjamin Franklin's. Can they still make a workers' compensation claim?
They can. They're still covered. Where it gets a little dicey though is like some companies use a payroll company, and those are very difficult cases where, and I have one now going on with a guy that has a substantial injury, fell off a ladder, broke his foot, his surgery, and the company was using a payroll company to do the payroll and administer the workers' comp, but the company that the guy was working for never reported him to the payroll company, was paying him in cash. So there's no workers' comp. The payroll company says, hey, you didn't tell us you hired this guy. We're not obligated to cover him. And, that's mostly true. And so I need to look towards the employer directly to satisfy, any sort of judgment. It's not a pretty case. But so the answer to your question is, most times if you're getting paid in cash, you're still going to be eligible for workers' comp unless your job is using one of those payroll companies. And if they never called it into the payroll company, then you're going to have a problem.
You're in trouble.
Yeah, it's a problem.
Well, I know that I run a business, you run a business. It's required that you maintain workers' compensation coverage for your employees. But as we know, not everybody follows the law.
No.
So what happens if somebody finds out that their employer does not have workers' compensation insurance?
It happens. So Jeff, it's like a coin toss. I mean, we'll sign them up. We'll sometimes you don't find out till like later on. And sometimes, Jeff, we're successful and, the employer will still cough up money. They'll hire an attorney and they'll still go to mediation and you'll settle with them. But, truth be told, you're not going to get as much money out of an employer that doesn't have insurance. As you know, if your client gets into a car accident and the other driver doesn't have insurance, what are you going to do at that point? You're going to go file a lawsuit and try to get blood from a stone?
Right.
Well, in workers' comp, it's kind of like the same thing. Some employers have more money than others, and sometimes you can get money still from them. Other times it's like, I have to drop the case sometimes because I'm not going to get a dime out of it. So those are unfortunate situations.
Well, what can happen to an employer who does not maintain that coverage?
Well, they can get fined, okay? Mm-hmm. And I have been sometimes I'll get a call every now and then, and it's not work that I do, but an employer will occasionally call and say, hey, workers' comp came in and they saw I didn't have coverage and they fined me. Can you help me? And I don't do that kind of work, and I have someone I can refer that to. But yeah, it does. I don't think it happens that much, Jeff, because there's plenty of companies out there that don't have it, that should have it, but they will fine you, and it's a hefty fine, very hefty fine.
Because
And they'll shut you down too.
shut down your business.
Yeah. So they'll be like, you're
oh,
not working.
that.
Yeah. So you're not working. Your business is closed, and you better, yeah. So
it's a little more than just a fine. It's the ultimate fine.
Yeah.
Well, how long does workers' compensation have to pay for your medical bills?
So the short answer is forever until you die, but there's a few caveats with that. So in order to keep your medical care open for the rest of your life, you would need to seek treatment at least once a year by going to an authorized workers' comp doctor. Now, there is a copayment, though. It's only a $10 copayment. But when the doctor places you at what's called maximum medical improvement, meaning you're plateaued and you're not going to get any better past this level, you're placed at maximum medical improvement. You got to pay a $10 copay. But you could theoretically, if you treat it at least once a year, go to that doctor for the rest of your life.
That doesn't happen.
It doesn't happen too often. So what usually will happen is some people will realize that, hey, you know what, I'd rather just, put this behind me, cash it in, get the money for my future medical care instead of like going to their not so great doctors. And that's where I come in to settle the case.
Well, I think part of the thing is with going to the workers' comp doctors, there's always that opportunity for them to cut off your benefits.
Well, your benefits do cut off when the doctor places you at maximum.
That's exactly what I'm talking. That's what I'm talking about.
Yeah. So you don't get, while your medical is open for the rest of your life, lost wages are not, unless. So the only time that you can get lost wages until age 75 is when you are declared permanently and totally disabled, and that, by the way, is like so hard to prove. The criteria to prove that is basically like Social Security disabled criteria, and it's very tough to prove. And you got to show that there's no work you can do within, I think it's 100 miles. But most of the time, Jeff, it's a situation where you're getting paid. You're on a no work status. You're getting 2/3 of your checks, and then you get released to light duty, where the doctor says, okay, you know what, you can probably go back to work. You can't do what you used to do. You got restrictions, but you can do some light duty, and then the workers' comp rate drops down just a little bit. And then eventually the doctor releases you to maximum medical improvement, and then workers' comp stops paying you. They'll pay you impairment benefits based on the impairment rating the doctor gives you, but that's like just like chump change. It's it's a small amount of money that you get for a few weeks, depending on the numerical impairment, and then they cut you off. And Jeff, here's the interesting thing, and this is something that we should have talked about before, was a lot of people think that once you get injured on the job, that you're entitled to future lost wages if you can't go back and earn the same amount of money that you used to make. So let's say, I was a plasterer and I was making, I don't know, $20 an hour. And then I get injured, and now my back won't let me go back and do that kind of work anymore. And I'm only going to be making $10 an hour in the future. People ask me, Adam, I should be compensated for the fact that I can't do what I was trained to do anymore, and I'm never going to make that same amount of money again. The short answer is no, you're not entitled to money in the future because you can't make what you used to make. Workers' comp doesn't care. That's the law.
If you do settle your case with workers' comp, do you always have to resign from your job?
Okay.
Because I know that a lot of times that's kind of a requirement.
It's true 99% of the time, and I'll tell you when it's not true. So, and let me tell you the rationale. The rationale for it is that when you settle your case, they don't want you showing up to work the next day. And then it's like, let's say you injured your back, and then they give you a settlement. You go back to work the next day. You go pick up something. Oh, my back. So do they have a new injury now? Is this a brand new accident, or is it the old one? Workers' comp insurance companies, they don't want to bother with that, okay? This isn't really your job's doing so much. This is the insurance company saying, we'll settle with you, but we want you to resign because we don't want to be placed in a position where you're claiming a new injury. Plus, it doesn't look good to other employees. Oh, hey, Joe's back here. He got a nice settlement. and he's still here. Maybe I'll have, an accident, that type of thing. So they really try to, most insurance companies will say, no, 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 we want a resignation. There are exceptions. There are some employers, Walmart is one of them, where Walmart will say, you know what, we'll give you a settlement, you can still work here. Don't ask me why, but they still do
So
that.
Walmart does that.
Walmart's like that. It might be another one. Another situation where you might not have to resign is if your employer changes workers' comp carriers sometime in between your case. Like while your case is going on, they didn't renew with that company and they went with another company. Well, in that situation, you got lucky because, the workers' comp insurance isn't insuring them anymore. So they don't care if you go and have another accident because it's not going to be on their dime.
Interesting.
Yeah.
Never really would have thought of that.
Yeah, it doesn't happen too often, but it can.
Let me go through a scenario with you, which I know that you've seen before.
Mm-hmm.
Person's driving a delivery truck for their employer. They get rear-ended by some schmo up behind them, wasn't paying attention, and they injure them. What kind of case do they have?
Well, Jeff, they got two cases.
Mm-hmm.
And one would obviously be what you do is the personal injury case against the guy that rear-ended you, and you go after their insurance. But because they were driving a delivery truck at the time, it also falls under workers' comp. So, yeah, in those situations, you can actually pursue both courses of action.
How does it work in terms of that? So they don't have to choose?
The answer is no, they don't have to choose. They can choose to do both. I will tell you that a lot of times, some people don't want to make the work comp claim because they don't want to, stir the pot, so to speak, and they'll only pursue the automobile case. But you definitely have the ability to go the route of pursuing both.
What about paying for medical bills? Can they go through workers' compensation or go through their own automobile insurance carrier through PIP?
So the answer is they can do either, but there's a caveat with that. So let's say you treat with PIP and you said, you know what, I don't want to go to you bad workers' comp doctors. I want to go to my own doctors. But then, let's say the doctors that you're treating with say, well, you can't work, you're hurt too bad. So you take that, no work slip and you want to show it to your boss. You want to show it to workers' comp. And guess what workers' comp does? They go, nope, because it's not their doctor. And by law, they're not obligated to listen to what the other doctor says. An unauthorized doctor, they're not obligated to follow the instructions of the unauthorized doctor. And they're going to be like, hey, that's not our guy. We're not going to listen to what that doctor has to say. So it's at your own risk if you only treat through, if you don't go to the workers' comp doctors.
But it's understandable that sometimes people would not make the workers' comp claim and just do the personal injury claim.
Happens a lot.
And in some instances, it would make sense to just do the workers' comp.
Well, if there's no BI case, if there's no insurance on your end,
sometimes it's your only option.
That's true. That
because if you're going, like you said, if you're going after a uninsured employer as opposed to an uninsured negligent driver, it's pretty much the exact same thing.
Yeah, it's never a good situation.
Not at all. Well, if you do have both claims, and let's just say workers' compensation pays for all your medical bills, if you get a good settlement in your personal injury case, are they entitled to get paid back?
Oh, they sure are. They have a lien. And the lien doesn't just take into account medical bills, it also takes into account all the lost wages that they paid you. So the whole settlement and all the stuff that they paid before the settlement becomes part of the lien. And then what you have to do is you take that lien, and that lien will actually, it sounds like not a good thing, but you can actually use the lien to your advantage in what you do, because that lien becomes your damages to show to the insurance company on the car, on the bodily injury.
Sure.
Look at all this money that's got to get paid back to workers' comp. You need to give a big settlement here because these are concrete damages that a jury would award, because here it is in black and white. The workers' comp paid this much for lost wages. They paid this much for medical bills. There was a settlement. There it all is, and that helps you to get more money.
And unlike a lot of the cases that I have where you have monstrous medical bills that sometimes remain unpaid on letters of protection, these are all paid and verified by an insurance company.
Yeah.
It's kind of hard to say, oh, they're too high.
Yeah, and very true. Plus, workers' comp fee schedule is, they shred those bills. I mean, like Medicare has a fee schedule.
Sure.
So does workers' comp, and they pay very little for these treatments, which is why these doctors really don't care to like really go the extra mile, because they get paid so little from workers' comp. They just don't want to spend that much time with you to really get to the root of the problem.
What changes have you seen over the past few years with Florida workers' compensation claims, and has it been good for employees?
It's right now. It's an upswing. It's favorable right now, and it's been likened to a pendulum over the years, where it'll swing back and swing for. And here's what it is, Jeff. The legislature always tries to save these insurance companies money, and they'll write they'll trim away these benefits and that benefits, and then the judiciary goes and says, nope, that's unconstitutional, that's not right, you shouldn't have done that, and they'll chip away at what was what was in the statute, and it'll get rolled back to an earlier period in the statute. Right now we're in one of those phases where there used to be a 104-week cap to the amount of benefits you could get if you're on a no work status or a light duty status. You could only get workers' comp checks for a max of 104 weeks. That was ruled unconstitutional, so this got rolled back to a very early part of the statute. I forget what year, but maybe they had the statute as it was 20 years ago or something like that, and now it's like 5 years. So right now we're in the upswing, but man, I'm telling you, Tallahassee's always looking to help the employers out and the insurance companies out and cut away the benefits to the injured worker.
Well, Adam, this has been a really informative discussion. I learned a lot because, again, I'm on one side of the fence and you're on the other, and I know you do some PI as well, but it has been very interesting to hear about the differences. And if anybody wants to get in touch with you, how can they do that?
Give me a call. My number is 305-770-2131. And Jeff, so I have an office in North Miami Beach and an office here in Coral Springs, I practice all over the state. I mean, I've got cases in Orlando and Lakeland and St. Pete. I mean, I'm all over the state. We do not shy away from taking cases, no matter if it's a workers' comp case in the state of Florida, I'll handle it for you.
What courts are these cases tried?
They're the judge of compensation claims, and there's different divisions all over the state. Every county, has one. So, that's where.
And you cover them all.
I'm there.
That's great. Adam, it's always great seeing you.
Yes, thank you, Jeff.
We'll be with you later this month. I'll have Jason Handon, board-certified construction law attorney, my former law clerk as well. So I'm really excited about that. If you ever have any questions, any legal questions for me, my name is Jeff Adelman, and my number is 954-341-2777. Have a great weekend, everybody.